And on behalf of the entire Supreme Court, welcome. It is a real honor for all of us to share today's proceedings with such an esteemed and distinguished group as is in this courtroom today. We have retired Chief Justices and Justices, Associate Justices of the Supreme Court whose service dates back 35 years on the court, Governors Corzine, Byrne, DeFrancesco, leaders of the legislature from both sides of the aisle, both houses, assignment judges and other judges from throughout the state in our state and federal court systems, students and friends of the court, represented by the many bar associations that are here today, members of academia, and people from other walks of life, members of the media who follow the work of our court on a day-to-day basis and in so doing perform a valuable public service, and dedicated members of the judiciary, present and past clerks and directors, and our very valued staff who comprise the backbone of the judiciary and make up our court family. Now, aside from identifying the governors by name, I have deliberately avoided identifying anyone else because each of you is truly deserving of a separate introduction, and to go that route and to speak fairly about your special relationship with the court would turn this into a very long program. So I've taken my own secret ballot. That approach did not pass, and we're going to try to proceed. Thanking you for your understanding. Today's a time for celebration as we mark the 60th anniversary of our modern Supreme Court. The first court term under the 1947 Constitution took place in September of 1948, and it was a time of monumental change in our system of justice. To highlight some of that change, let's focus very briefly on three fixed points in time, beginning 61 years ago, when our court was comprised of 17 different courts with overlapping jurisdictions. If you've had a chance to take a look at the programs that are in front of you, you can see the flow chart toward the back, which I think can more fairly be described as a spaghetti flow chart. And as amusing as the organizational structure of the time may seem today, it was a serious problem for our citizens, a very real problem 61 years ago. There were 9,000 untried cases, including some that were more than 15 years old in the court system, each of them representing a delay in the delivery of justice with a real impact on our citizens. And it's fair to say, regrettably, that our court system had the reputation as being, if not the worst, among the worst legal systems in our nation at the time, living up to the description that Charles Dickens included in his works about judicial systems. Let's move ahead 60 years ago, one more year from that first starting point. The September 1948 term began with not 17, but a streamlined version of 5 courts. No more overlapping responsibilities with cases moving from court to court, languishing before they could be heard on the merits, a straightforward appellate process. And in that first year alone, our law division judges tried 98% more cases than the year before, and our appellate judges resolved all ready cases before the summer recess. The new structure has certainly endured the test of time. Today, New Jersey ranks at the very top of judicial systems throughout our nation under whatever measure someone might choose. It's a system that has witnessed quick and ever-improving change for the betterment of our state. How did we get there? A number of ways, starting with the leadership of giants who served on this court over the course of decades, beginning, of course, with first citizen and then Chief Justice Arthur Vanderbilt, whom we'll hear more about momentarily. Also, the change came about through the support of a number of important political leaders, including Democratic Governor Charles Edison, his Republican successor Alfred Driscoll, members of the legislative branch, and attendees at the 1947 Constitutional Convention, all of whom cared deeply about making our system work better. Now, to be sure, there were some very strong opponents. Legendary Jersey City Mayor Frank Hague, many sitting judges, and a good number of lawyers. But to overcome that opposition was the overwhelming support of ordinary citizens, who, unlike just years before, showed up and voted by a substantial margin of 3.5 to 1 in favor of the reforms from the Constitutional Convention of 1947. So today, we start the 60th term under our modern Constitution. And it's remarkable to see both some of the changes and what has remained constant over the years. The modern Supreme Court heard its first arguments on September 15th of 1948, and they heard 3 cases that day, including a lawsuit that was brought by Elizabeth Bowes. On March 24th of 1944, Ms. Bowes went to work, fell, and slipped as she was headed toward her office. She sued the owner of the building, the Metropolitan Life Insurance Company, and testified at the trial that she slipped on the metal sill of the elevator cab and that the floor had been waxed and was too slippery. She didn't win at the trial or the appellate level, and she didn't fare much better at the Supreme Court, where its members, all white males, unanimously agreed that she had not proved the elevator was constructed in a defective way or maintained negligently. Today and tomorrow, our court will hear argument in 9 cases. One of the cases, scheduled for tomorrow, was brought by the estate of Mathy Khan Polzo. Ms. Polzo was riding a bicycle on the shoulder of a road maintained by a county. She was involved in a serious accident in the vicinity of a large pothole and tragically lost her life. The court will hear argument about the duty of care that the county owed in maintaining that road and the level of proof regarding that subject, echoing some of the very points in Ms. Bowes' case of 60 years ago. Now, as for some of the changes in these similar sounding matters, in September of 1948, if you wanted to listen to that case, you'd have to get up early, make your way down to Trenton, find an empty seat in the courtroom where you are right now. Tomorrow, as is true for every argument this term and in recent memory, you can simply turn on your computer and listen to a live webcast of a streaming live display of the arguments, or hear it on the archives at your pleasure, turning on the website. In 1948, this case, by the way, was granted as a result of a petition for certification, one of 1,200 that the court reviewed in its last term. During the 1948 term, there were a total of 15 cert petitions that the court received. And while that may not mean a great deal to many of our attendees here today, I can see the smiles on the justices who have painstakingly reviewed and presented one by one the cert petitions over the years. Perhaps what's most striking, though, is what has remained the same. When we think about our Supreme Court, we think about the very important and difficult cases that it takes on, matters that affect the very vitality of our state, that go to the fundamental rights our citizens have under the 1947 Constitution, cases that rightly attract attention in the popular media and in the legal journals. Ms. Bowes' and Ms. Polzo's cases are not the type that would necessarily garner headlines, but they matter a great deal. They are perfect examples of how ordinary citizens come to our courts when they believe they have been wronged, when they seek to vindicate their rights. They're entitled to, and we believe they receive, genuine respect and courtesy from the judges and staff that handle their matters, a careful, thorough, and prompt review of the legal issues that are presented, and an honest, impartial, and wise decision that focuses only on the facts and law of the case, not at all looking at the parties and what their backgrounds may represent. Litigants have every right to walk out of this and every courtroom in our state disagreeing with the decision. But we hope that they will walk out with a sense that they've received a fair hearing, a fair shake, the ultimate benchmark in any system of justice, today or in 1948, a measure that we strive to attain in each case, in every courthouse throughout the state, each and every day.
Thank you, Justice Rebner. I've always sought to be a lawyer and have a chance to argue a case before the court. Somehow or another, my law school LSAT scores were so low that I never really had the chance to come visit. But it is an honor to be here with this distinguished court, and for all of those who've preceded you, it is a remarkable set of individuals that have served on this court throughout the years. Chief Justice Zali is here, Poritz, other justices, Handler, Pollack, Venero. It really has been a great, great tradition from the beginning to where we are today. And I'm honored to stand here as the governor of this great state, proud that our court has shown such leadership and as you said, fairness of attention to both the law and the facts being the basis on which decisions are taken. It's also great to be here with Governor Byrne of DeFrancisco, Speaker Roberts, Senators Kaine and Lance. Senator Lance has a special feeling with this court, as his father was an integral part of writing the Constitution that brought about the consolidation and unification that you talked about. Senator Smith, Assemblyman members DeCroce and Greenstein. And I'm honored to be here with Arthur Vanderbilt, author and grandson of the original Chief Justice. For all of those that are here to celebrate, and we are celebrating, this great court is a humbling opportunity for me to speak before this court and in front of people who care so much about equal justice. It's a remarkable group. It even has Senator Bill Gormley here, who comes back from history to. Have you ever spoken here, Bill? Never quite sure, but I always get nervous when he's in the room. But let me say, the history and tradition is remarkable. This celebration is important. The disposition of equal justice is one of the fundamental ideals and visions of this great state and our nation. And all men and women are created equal, and when they enter a court of law, they have a right to expect to be treated justly. And this court has done that, sometimes at the expense of the judgments that have been taken in other branches of government, our regulatory regime, and it is absolutely essential that our citizens have the ability to have their day in court. And you all have done a great job, whether it is with intended or unintended consequences. And I will say, as the Chief Justice mentioned, not all cases are on the front pages of the newspaper, but there are a few that have been. I think if you look at the public discourse over the 60 years, this court, the modern court under the 1947 Constitution, has taken on in a way that is path-breaking for our nation, whether it is with respect to education and the landmark Robinson and Abbott decisions that have outlined the contours of equal access and equal outcome for children, whether it has been in the groundbreaking rights of those who carry questions with regard to sexual preference, the Dale versus Board of Scouts of America, or the Lewis versus Harris case, which most recently established the framework for our civil unions laws in the state, the right to die notions were involved in the Quinlan case, the Mount Laurel decisions with regard to affordable housing. All of these are pathfinding, not only for New Jersey, but for the nation. And we are proud of the progressive force and the balanced force that this court has brought to ensure justice for all of our citizens. Make no mistake that Abbott carries a whole set of meanings to people who are involved in the educational decision, not just here in New Jersey, but across the country. I hear it on a regular basis among my colleagues in government and among other governors. Mount Laurel carries a whole set of expectations and responsibilities. The accountability that the court has brought to all of us to live up to that vision of what our ideals are in the Constitution is truly remarkable. And I congratulate not just this court, but the historic judgment that has been expressed. We're proud of all of you. We're proud of the legacy. I'm honored to be a governor of a state where you can look to the court and understand that there will be fairness, that there will be attention to both facts and the law, and we look forward to your great leadership in the years ahead, not only this court, but your future mentors, and I thank you very much for giving me a chance to speak.
We're grateful to have with us a number of legislative leaders, and I understand they may have some resolutions and words to offer. I call upon first Senate Minority Leader Tom Kaine and Senator Bob Smith. They have both served in the Senate since 2003 and the General Assembly before then. Senator Kaine had been a member of the Senate Judiciary Committee. Senator Smith currently is, and he is a practicing member of the bar as well. Thank you, Senators.
Mr. Chief and members, it's my honor today to stand in as representative of the Honorable Dick Cody, who unfortunately couldn't be here. But he asked me to express the great respect that the New Jersey Senate has for this wonderful institution, and especially as a result of the Constitution. We have a joint resolution, but let me just point out, as a legislator who's been a legislator for about a third as long as the Constitution has been in existence, that you institutionally are the people who keep us on our toes. When we go beyond what we should be doing, either legislatively or regulatorily, you very kindly and respectfully slap our hands and get us back on the true path. And when we don't do what we should be doing for our citizens under our constitutional mandates, you also slap our hands. So as a legislator and a member of the other body, the legislative body, keep up the good work. Senator Kaine?
It's an honor. It's humbling to be here before the court. I want to thank you on behalf of my colleagues, Senator Smith, members of my caucus, Senator Lance, who will be addressing you later, as well as former members of my caucus, Senator Gormley, who was so ably the chairman of the Judiciary Committee for so many, many years. On behalf of my caucus and behalf of the State Senate, I want to thank you for your diligence, your hard work. I know we in the legislature don't always agree with every single one of your decisions. But that's part of what advancing the cause of democracy and the human condition is all about, is working together, finding solutions, having the same end goals in mind, which is making sure that this great state and this great country is a far, far better place for this and the next generation. And so on behalf of the State Senate, along with Senator Smith, I want to thank you for all of your wonderful, wonderful work. Thank you.
We're honored to call next upon the leaders of the General Assembly, Assembly Speaker Joe Roberts, Minority Leader Alex DeCroce. Speaker Roberts has been in service since 1987 and also served as Majority Leader, and Minority Leader DeCroce has served in that position since 2003 and in the Assembly since 1989. We welcome both of you.
Good morning. Thank you very much. I'm certainly pleased to join my friend, the Minority Leader. And Mr. Chief Justice, let me just indicate that Assemblywoman Linda Greenstein, who is the chair of our Judiciary Committee, is here and has worked very, very hard on these issues and continues to do so. First of all, Mr. Chief Justice and justices and former Chief Justices and members of the court, members of the judiciary, I'm certainly happy and honored to join my colleagues in the executive and legislative branch in being here to honor this extraordinary achievement and anniversary. It's clear that those who worked on the Constitutional Convention in 1947 got it right. And their work has been validated by time, and also by virtue of the fact that when places like Alaska and Hawaii became states in the Union, they looked all over to find a way to develop the best court model, and they emulated the New Jersey model. So I think that speaks volumes. I've always been both puzzled and disappointed by those states that have taken a different approach to the selection of their judiciary, relying on the electoral process, not utilizing the merit selection model, blurring the lines between politics and justice in a way that has really not served the interest of their states. And I think in many ways the commitment of New Jersey, the excellent commitment of New Jersey, has really served as a model of how things can be done in the most proper fashion, and it is really to our credit. As Senator Kaine said, folks who work in the building where I work don't always agree with every decision that is made by this court. I will tell you I agree with more of them than I disagree with. But the integrity of this court and the commitment of this court to justice and the standards of excellence that this court has set have never been questioned by anyone. And that is to the extraordinary credit of our state. So congratulations on this 60th anniversary. I know that as we're at 60 today and moving towards 70, many people think about the magic number 70 and the retirement age, the mandatory retirement age. Thankfully, while that may apply to individuals, it doesn't apply to the institution of this court. So I know that you will continue doing your great work and making this state better for many, many years to come. Thank you very much.
Chief Justice and Justices, certainly a Republican majority, a minority, is very appreciative of your work, and certainly we want to congratulate you for your years of service to the people of the state of New Jersey. Again, I do agree there are times that we don't always agree together, but there are times we agree more times than not. In fact, the 2 or 3 times that we've been able to come before the court, we've been very happy with your decisions. So I will say that we welcome another period of years working with the court, and look forward to your continued success. Thank you.
Arthur T. Vanderbilt II is not only the grandson and namesake of the first Chief Justice of the court, but he's one of the foremost historians of our judiciary and the New Jersey Supreme Court in particular. He's authored a number of books, including Order in the Courts, a biography of Arthur T. Vanderbilt, and Jersey Justice, 300 Years of the New Jersey Judiciary, co-edited with Carla Bello. Among other positions, he has served as a law clerk to Judge Michaels, an assistant counsel to the governor, and as a practicing attorney. Mr. Vanderbilt.
Mr. Chief Justice, thank you. Members of the court, Governor Corzine, Governor Byrne, distinguished guests, try to imagine sitting in the State House Annex on this day 60 years ago. Picture yourself as one of the men or women, for yes, women were an important part of this whole process. Picture yourself as one of the men or women who had worked so long and so hard to bring about the Constitutional Convention of 1947, the adoption of a new state constitution, and the complete reorganization of this court system. Imagine it. You had worked 17 years to reach that day, 17 years of toil and frustrations and defeats to try to improve the administration of justice in this state. It all seems so obvious in retrospect, doesn't it? But do you realize that our state bar association opposed it, as did every county bar association, as did every sitting judge except literally 2 or 3, as did the most powerful politician in the state, Mayor Frank Hague? When did I mention the Chief Justice testified in opposition to it that summer in New Brunswick at the convention, as did the Chancellor, and those were the 2 highest judicial officers in the old court system. Imagine sitting here 60 years ago. Can you understand the pride these men and women must have felt in what they had accomplished? And can you imagine the fear? For surely they must have been thinking, oh my God, what if this thing doesn't work? But they made it happen. They made it work with those same sitting judges who had opposed it. And to make it work, they prevailed in those early years after 1948 against some pretty brutal attacks by the legislature. And it wasn't long before this new court system was widely recognized as the best in the country. And it wasn't long before this court was widely recognized as the best in the country. And it wasn't long before the changes brought about here in New Jersey were being used as a model to restructure other state court systems across the nation, and indeed the court systems in other countries all around the world. That's what began here in New Jersey 60 years ago. Now, at the risk of losing royalties on the sales of my books about this court system, I'm going to give you the Cliff Notes summary. The men and women who sat here 60 years ago did not think they had created a perfect court system. They knew it was a good structure, but they realized full well that it was a system that would have to be continually refined and revised to meet the changing demands placed upon it. It was not a static system. It was a system that would have to develop and grow to maintain its ability to administer justice efficiently and effectively and impartially. When Chief Justice Rabner was appointed last summer, I remember reading an interview with him in the Star-Ledger. In it, he mentioned how he was asking everyone he met to tell him 3 ways the court system could be improved. Bravo, I said to myself, he's got it, he's really got it. And I sent him 3 ideas from my own law practice. It is this spirit to embrace new ideas and change that is so important to keep our court system and our judiciary at the highest level of regard, which have been held for so many years. May that commitment to change that guided this session 60 years ago continue on today and be always a part of your work.
Thank you. Senator Leonard Lance is no stranger to anyone in this room. He, too, was a law clerk for not 1 but 2 judges, former assistant counsel to the governor and a member of the Senate since 2002. He is, of course, the son of former New Jersey Senate President Wesley Lance as well, who played an instrumental role in the development of our 1947 Constitution. Senator Lance.
Mr. Chief Justice, may it please the court. We would not be celebrating the events of 60 years ago, except for what happened 61 years ago. And that could not have occurred except for the magnificent efforts of many in the 1930s and the 1940s. Credit belongs to a series of governors. Walter Edge, who tried to get a constitution enacted in 1944 by operation of the legislatures serving as a constitutional convention. And that effort was defeated in the election of 1944, due principally to the actions of Mayor Haig. Of his predecessor, Governor Edison, who courageously argued for reform of the constitutional system. And of course, to Governor Driscoll, who, when he was elected immediately upon his inauguration, indicated that this state would have a constitutional convention. And Governor Driscoll is credited because he made the compromises necessary to assure that a constitutional convention would occur. Most thought that the convention should be comprised of 60 members based upon apportionment, based upon the 60 members then sitting in the General Assembly. Governor Driscoll compromised with the legislature to increase that membership to 81. The 60 members of the Assembly and the 21 members of the Senate, 81 delegates were elected from across the state, not necessarily completely based upon the principle of one person, one vote, but the compromise necessary to ensure that a convention would occur. And he compromised successfully with Mayor Haig as well. And as the result, there was the convention in 1947. And particularly regarding the judicial article, Dean Summers' work as chair of the Committee on the Judiciary, and the work of the vice chair, Nathan Jacobs, who had been an associate of Arthur T. Vanderbilt. Arthur T. Vanderbilt is principally responsible for the judicial article, and although not a member of the convention, Nathan Jacobs spoke with Arthur Vanderbilt virtually daily in the summer of 1947 from Arthur Vanderbilt's summer residence in Maine to make sure that the judicial article would encompass those principles for which Arthur Vanderbilt had fought for at least 2 decades. Carla Bello and Arthur Vanderbilt II have written marvelously about this institution. And in their book, they quote Russell Watson, who said 60 years ago this week, "The Constitution of 1947 worked fundamental and far-reaching changes in the functions, powers, and duties of the legislature and executive branches of the state government. The treatment of the judicial branch was of much broader scope. The old judicial system was virtually obliterated, and a new and different one, which emerges today, was substituted for it. This, therefore, is the most significant segment of the new Constitution, the enactment of which is the most significant event in the history of New Jersey since the adoption of the Constitution of 1844. Your distinguished predecessors on that first new court, Arthur Vanderbilt, Clarence Case, who had been Chief Justice in the old system, Dayton Oliphant, from a distinguished New Jersey family, whose uncle, William Dayton, was the first Republican candidate for vice president in 1856 and Lincoln's ambassador to France, Harry Heyer, William Wachenfeld, Albert Burling, and Henry Ackerman, all distinguished justices, and you serve in that tradition of your first predecessors. Chief Justice Case, as a new Associate Justice under the new Constitution, was succeeded by Nathan Jacobs, so responsible for the work in the summer of 1947. And of course, Justice Ackerman was succeeded by William Brennan, who then went to the Supreme Court of the United States. I have confidence in the judicial article of the new Constitution. It has been further strengthened over time by the merger of the county courts with the Superior Court, and can be improved in the future by yearly increases in salaries for the judiciary, so that judges will know in real terms what their compensation will be during their lifetime service when they go on the bench. I have confidence because you have served your mission. I predict that 40 years from now, our successors, and maybe even some of us, will be celebrating the 100th anniversary of the new court system. As on that date, we will be celebrating the 101st anniversary of the new Constitution, a document that will remain the single most important reform in New Jersey's history. We should all continue to be grateful to those brilliant men and women and to the 81 framers who forever stand the test of time in the work they performed on behalf of all of the people of New Jersey in 1947 and 1948, the people of New Jersey today, and the people of New Jersey in the future. Thank you very much.
Our next speaker is the Honorable James Coleman, Jr. And Justice, you are free to address this court from anywhere you'd like. That podium, this seat, your old seat up here, whatever is your pleasure. Justice Coleman began his judicial career in 1973 as a judge of the Union County Court. In 1978, he became a Superior Court judge, elevated to the Appellate Division in 1981, Supreme Court in 1994. He has played a key role in launching the Supreme Court's Committee on Minority Concerns, which is now celebrating its 25th year. Justice Coleman.
Chief Justice, Associate Justices, and other distinguished persons present today, you have no idea what a great pleasure I have derived from being able to stand before this honorable court and say, may it please the court. It has taken a long time to get here, but in the process, I had to start by asking myself and speculating as to why I may have been chosen to speak on behalf of the retired associate justices. My first impression was that it was probably because the other 8 of them had declined. And then I said, I doubt if that was the reason, because I don't think Justice Pollock would have declined. So I continued to probe as to why I was chosen. And I came to the conclusion that because we are celebrating such an historic occasion, the occasion indicates how the New Jersey court system has been a pioneer on the national scene with the establishment and the conduct of a high court, that perhaps the time that I spent in the judiciary, to some extent pioneering, may have been one of the reasons. And then when I looked at the official photograph of the 1948 Supreme Court, I failed to see that the court was yet diverse, and therefore, although the 1947 Constitution had established what has become one of the greatest court systems in the nation, it was not yet a perfect union. And so today I will speak briefly about some of my experiences that I will rely on later to help shape my conclusion as to why I believe the New Jersey court system is the premier court system in the nation. I'm a little unique in that I served in all of the courts of New Jersey that were authorized under the 1947 Constitution. And while this celebration is not about me, some of those experiences while serving in those capacities will help to inform my ultimate decision. We start with the premise that it is quite plain that in 1844, that Constitution, consisting of 17 different courts, was a hodgepodge of English courts that prevailed in pre-colonial days and during the early statehood era in New Jersey, while in contrast to the 1947 constitutional court system, we have a very, very modern system. But as noted before, that excellent system on paper had a little to be desired in terms of the public's perception of the makeup of the court. In addition to that, that perfect court still permitted the county judiciaries operating in their respective 21 counties to operate with some level of independence, and hence court unification became extremely important. As someone has already indicated, that process was started with the 1947 Constitution, and it began to be perfected in 1978 when the Constitution was amended to merge the county courts with the Superior Court, and finalized in 1983 when two of the existing courts established by the legislature under the 1947 Constitution were merged, and that would be the county district courts and the county juvenile and domestic relation courts were merged with the Superior Court in 1983. After having had a merger and a unification of the court system, it is quite obvious then that centralized management of such a strong judiciary would be ideal. And the Supreme Court's decision to pass rules to implement all of the policies and operate the court system was very helpful in that regard. Hence, an administrative director of the courts was appointed to help fortify that centralized management. And as a side issue, that individual today represents more diversity in the administration of justice. What are some of the things that have made the New Jersey judiciary so very important among the state courts? I start with the judicial independence, and that independence was created by virtue of the appointment process initially. So many states in the Union have a different way of electing judges, and I won't exceed the allotted time by discussing that. But the manner in which a justice or a judge reaches the court has a tremendous impact on the independence. The court has recognized, that is, this court has recognized that in the formation of the Republic, and I quote, "The complete independence of the courts of justice is peculiarly essential in a limited constitution, that any lessening of the independence of the judiciary attacks not only the judicial power, but the democratic republic itself, that we would rather have an independent court, a fearless court, a court that will dare to announce its honest opinions in what it believes to be the defense of liberties of the people, than a court that, out of fear or sense of obligation to the appointing power or factional passion, approves any measure we may enact." The court said just that in 1986 in the Randolph decision. The judicial selection process, as noted before, has had and will continue to have a profound impact on the judicial independence in New Jersey. During the Supreme Court's first 35 years of operation under the 1947 Constitution, as someone said earlier, only white males were appointed as justices. That changed incrementally beginning in 1983, again in 1994, again in 1996, and finally in 2004. Similar changes have been occurring in the Superior Court of New Jersey beginning in the 1970s. But did those changes make our system better? I respectfully suggest that they did, both in terms of the appearance as well as in terms of reality. I served with or under 5 of the 8 chief justices appointed to this court under the 1947 Constitution, the exception being Chief Justice Vanderbilt and you, Chief Justice Rabner. Each one has been to paraphrase an earlier statement by Justice Handler, quote, "and unwavering in his or her commitment to preserving the integrity and independence of the judiciary. They have sought to protect or project a judiciary that would be regarded as fearless and honest. They believe that the courts existed only to serve the people and to do so with independence and integrity." Chief Justice Will Lynch best summarized my feeling about our court system when he announced his retirement on June 13, 1996. He said, I quote, "We have a fine court system still supported by the people of New Jersey in these somewhat difficult times. That support is one of our most important sources of strength. The ultimate source of strength and integrity remains our own commitment to judicial independence, total and uncompromising. During my tenure as a judge and an associate justice, the courts used the law creatively to heal the wounds in New Jersey and to protect the disadvantaged. I was part of a court system that modeled the law to make it what it ought to be, and in the process, maintain stability without stagnation. The justices over the years have used their independence when deciding such cases as Abbott school funding, Mount Laurel open housing, New Jersey Coalition Against the Wall leafleteering in shopping malls, In re Baby M motherhood surrogate, In re Byrne, the right to an abortion, State versus Gilmore, non-discriminatory jury selection process, State versus Maryland and Carty, outlawing racial profiling when stopping people to question them, and the death penalty jurisprudence that paved the way recently for abolishing the death penalty by the legislature in this state. Those are but a few among a much larger list of cutting-edge cases that helped to make New Jersey Supreme Court the premier court of last resort in the nation. My former colleagues and I are proud to have been part of this institution's evolving greatness. When I became a judge in 1964, I saw the statue of justice in much the same way as did the poet Langston Hughes, namely, as bandages hide into festering sores that once were perhaps arise. When I retired in 2003 from this great court, because of the delivery of even-handed justice by the judges and justices of the system, I saw the statue of justice as an optimist, as the goddess of equal justice for all. That speaks volume for the progress made in our judicial system. The challenge to you, Mr. Chief Justice, is that during your anticipated long term as Chief Justice is to find ways to continue to make our near-perfect system better. Although that is a daunting task, I have every reason to believe you will meet it. God bless this honorable court.